friends, welcome to my Lochan channel. Here is my video. The law comes to us in lawyers from the general to the specific, from board sweeping concepts that are almost universally accepted to billable standard that often are subject to debate to nitty-gritty rules that marks the battle lines in any given case. Now that the public questioning of Supreme Court Chief Justice nominee John G. Roberts Jr. is over, it's worth explaining how these various lawyer played into the Senate Judiciary Committee's work and how committed Republican and Robert himself relied upon them to his great advantage. Senate Democrats on the committee wanted Robert to share his views about those understands and rules. They wanted to get him to talk about the law at its routes along the margins where cases are decided and new law is made. They wanted him to get to at least the second lawyer of the law. When Google Work Space for Business is what upgrade. Neither side pushed Roberts too much to get down to third lawyer, and rightly so. Judicial nominee ever should have to predicate how he or she will rule in particular case. Every lawyer in American believes in the principle all star decisis, for example, so it was absolutely inconstitutional for the nominee to have made such a big deal about it. Likewise, his focus in his answer often is started reverence for the rule of law does not tell any lawyer or judge anything new or profound about the judicial philosophy. Can you imagine or lawyer coming before any legislative committee and expensive disdain for the rule of law? Of course not. But as we saw during the Florida recount fiasco of 2000, the rule of law means many different things to many different people. This is surface level stuff, enormously broad strokes, meaning so much that in this context it really means nothing at all. So for example, when Robert mentioned that the belief that the constitution includes a right to privacy, committee Democrats response reasonably enough wanted him to be beyond that broad universal concept to explain more precisely what that phrase really means to him. That they quite rightly noted that conservation Supreme Court Justice Antonin Scalia's idea of the right to privacy is very different than when liberal Supreme Court Justice wrote whether Ginsburg's idea of the right to privacy is. This is the important because right to privacy, whatever it means, is the foundation of the court's abortion right ruling and any other ruling that implicate the personal or intimate conduct or relations of the American people. Most community Republicans, for their part, were happy to accept Robert recognition of a general right to privacy in the Constitution. Constitution for them. If for them this first lawyer answer satisfies whatever obligation the nominee may you have had to share his legal views and philosophies with the Congress before taking a seat on the High Court. It allowed them and the nominee to say with straight faces that Robert had been forthcoming about what kind of justice he is likely to be for their next 30 years. So friends, here is my video. Please subscribe my Lojan channel.